Linda, who will take you through today's topic, the Good Work Plan and changes coming in April 2020.
Hi everybody, today's topic is the Good Work Plan, and most of us will have already heard something about it. It was published in 2018, and what it did is set out numerous employment law recommendations, not all of which are either at the moment coming into force at all, or have we got a date planned for them. So today's webinar is to mainly cover the stuff that's imminent, that's coming in on the 6th of April, and rather than the entire subject, which is huge for some of you that maybe have had a look at it already. Okay, so the changes that you need to be aware of from my perspective at this moment in time is changes to principal statements, changes to the holiday pay reference period, changes related to the rules regarding breaks in continuous service. Just important to note that that's not actually coming in yet, but it is important to cover off, I feel, today. And then the financial penalties in the tribunal and the naming and shaming powers. Okay, so the Good Work Plan. So as I already said, it was published in 2018. In 2017, the Prime Minister at the time, Theresa May, commissioned Matthew Taylor to review the employment law. The objective was that work in the UK should be fair and decent with a realistic hope for development and fulfilment. So back in 2019, the government introduced already the right to a payslip, which was only previously for an employee, which has now been extended to cover all workers. So that's already in place. Payslips must also outline hours worked for the hourly paid so that people know what they're actually getting paid, which you would think it was logical, but it wasn't the law. So not all employers introduced it. And then there's also been an increase in maximum penalty for aggravated breaches of employment law. So the plan was initially published at the end of 2018, and some of the changes, as I've said, are due to come into force on the 6th of April this year. All businesses really should be ready to deal with the changes and understand how they're going to affect you as a business. So this webinar is intended to guide you through the main changes and give you some tips about how to get prepared for future changes. Okay, so the first thing I want to discuss today are principal statements. So from the 6th of April, new starters must receive the principal statement on the first day of employment. So currently under Section 1 of the Employment Rights Act, a written statement of employment particulars, which is a fancy way of saying it, must be provided to employees, not workers, which is important to know, within 2 months of their start date. Now, this is now going to change, and it is going to have to be a day one right. So what they're saying is that it should be given either before starting or on day one. My advice is to issue it on day one rather than prior to starting work. Now, it's not always known as a principal statement. There are other names used for it, but basically it's your contracts of employment, and that needs to be issued on day one. They've also extended the data that should be contained within this principal statement. So previously, it was just your place of work, your start date, and it's now also going to include things like your details of any probationary period, including the conditions and its duration, the days of the week the individual is required to work and how any variation is going to be determined, details of any paid leave that the individual is entitled to. It's also going to include things like maternity leave and paternity leave, details of any training provided by the employer or any other training which the employee will be expected to pay for, and then details of any benefits provided by the employer. So these generally were all in the background somewhere, not actually contained in that principal statement, but what the law is going to say from the 6th of April is they all must be detailed in that principal statement. So it's important you know what you say to your employees when they start work for you. If you don't know, review your documentation. If you're already a client of ours, come to our policy team and just check that your documentation is up to date. And if you've not already got documentation, it's important that you engage somebody's services. Come to us, we'll review what you've already got, make sure it's lawful and that it takes all this into account. So moving on to changes to holiday pay. So basically at the moment, when you calculate your employees' holiday pay, you will look back at the previous 12 weeks. So from April, the government is increasing this reference period to 52 weeks. This will allow greater changes, greater flexibility for workers choosing when to take the holiday, particularly those in seasonal roles, and they ensure they benefit from their full entitlement. Because, so say you didn't work at all over the summer months, if you're calculating somebody's, or you work reduced hours even over the summer months and greater hours over the Christmas period, you will have an inconsistent value when you take holidays following a period of less hours. So going back the 52 weeks will give you greater consistency when calculating what people should expect when they take time off work. It's also important to note that you should be including any irregular overtime bonuses and commission in these calculations, not just looking at the actual pay for the hours worked, to ensure that the employee doesn't suffer detriment as a result of taking annual leave. So it's not just the hourly rate that you need to consider. There is a wider issue here with holidays, and employees shouldn't suffer a detriment as a result of taking this time off work. Okay, so the break in continuous service. Now, I've already had questions on this on the advice team, from the advice line, and even though it's not actually planned for this year, for April 2020, it may be something that comes up in later on in the year, or even not at all. But like I say, I am already having questions on this, so I feel it's important to just make people aware that currently a gap of 1 week, including 2 weekends, which is important to know, can justify a break in continuous service as long as there's no conversation talking about potential of an employee or an ex-employee coming back to the business in this time. If there's a clear gap, a P45 issued, a 1 week, including 2 weekend gap, can break service. Now, going forward, what the government want is that gap to be 4 weeks. So it's clearer. It's in line with other legislation as well, like redundancy, so that we have that clear gap in employment before re-engaging somebody, to make it less of a risk of the business for claims going forward. So, but like I say, at the moment, it still remains 1 week, including 2 weekends. Okay, so our final slide today is Employment Tribunal financial penalties. Hopefully, no one on this call will be subject to these penalties, but it's just something that has come in and is already in place, and I just feel it's important to just cover off. So from the 6th of April last year, the maximum penalty the Employment Tribunal was able to impose on an employer not paying as a result of a failed claim was £5,000. That is increased from the 6th of April to £20,000. Now that is a lot of money. That is a big increase, and this is why I feel the need to just cover it off today, because I suppose for some people £5,000, it's like, I'll make them wait for the money. It's, I'll do it at my own speed. But I think £20,000 is going to be a big impetus for an employer to ensure that they pay an employee out as part of a failed tribunal. And also the plans were to publicly name and shame. Now, I know there have been some cases in the media, but and I know that everything's online now, so we can all see who's been successful and unsuccessful in tribunal online. So, you know, this is real and it's already happening. So just be aware of it.
Brilliant. Thank you, Linda. What we're going to do now is move on to the Q&A period. We have had a lot of questions through, so do still keep dropping your questions into the questions box and we will work through them all. So in terms of the first question is, does the Good Work Plan change bank, casual, 0-hour contract staff employment status, or are they still not covered by the Employment Rights Act? I also wanted to mention that we have actually got an additional colleague with us for the Q&A session. Mike Fitzsimmons, our senior HR policy consultant, has joined us for the Q&A period, so he will be answering your questions alongside Linda. So I'll just repeat that question again. Does the Good Work Plan change bank, casual, 0-hour contract staff employment status, or are they still covered by the Employment Rights Act?
I'll pick that one up. Morning, everyone. Join our nightmare world. It's a very, very good question, this, and there's no easy or straightforward answer. Terms like 0 hours, bank staff, casuals, all mean different things to different people. And unfortunately, there is no good definition that we can rely on. For instance, we don't have a clear break in definition between what's self-employment, what is employment, and indeed the thing in the middle, what is a worker? So this is a good question. And the main Good Work Plan, that's the other 47 things that have not been introduced under the government's current proposals, propose that the definition of employee, worker and self-employed should be clarified. But at the moment, it's all in the courts to interpret in the way that they think. And you'll probably have seen there's been a number of cases around what's playfully referred to as the gig economy, companies like Uber, Deliveroo, Hermes and so on, where the status of particular individuals undertaking work on their behalf has been challenged. So although it was in the original Good Work Plan, the government has failed to pick this up as yet, which is regrettable. If they'd done that, it would have been a lot more helpful than some of the stuff they are doing today. What it has said is that every employee and now every worker must get proper written particulars on a day one basis. It doesn't matter how short the assignment. So if you are giving casual workers any form of assignment whatsoever, whilst it doesn't necessarily change that particular element of the legislation, the new regulations coming in say they have to have some sort of written particulars. But the definitions remain vague, but they must get those written particulars. If you're a more paid client, it's important to know that if you're using casuals, please make sure you're using our casual services scheme. We're actually looking at that at the moment to see if there's ways in which we can modify it a bit further to minimize the amount of fuss and hassle that this will cause you if you're regularly using lots and lots of casuals on an on-off basis, an if and when or an as and when basis. So that was a long-winded response, but to answer Kerry, the definitions are still unclear. But in a word, if you're using casual workers, Kerry, they must now receive workers' terms. It's not the same as an employee. Please don't issue them with a principal statement. It is not the same. They are not employees, but they must have some written terms on day one, even if day one is the only day they ever work for you.
Brilliant. Thank you, Mike. We'll now move on to the next question, which is, most of the Good Work Plan hasn't been enacted. Is it likely that all elements will be enacted at some point?
Well, again, this is one where I wish I had a crystal ball. Clearly, we've got a different government than the one which proposed these changes. It's the same brand, it's still a Conservative government, but it's a different Prime Minister. And quite clearly, the whole ethos of his government is different than that which Theresa May had espoused, and that's been witnessed in the last 24 hours very, very clearly. So no one can say what's going to come in and when. There's an awful lot of it lying around in the periphery, some of which, as I've already said, is important, like the definition of work, worker, employee, and self-employed. That's important, not yet dealt with. So one doesn't honestly know, but it's not so long ago we had things like grandparents' leave being talked about. That's gone nowhere. There were amendments to the modern slavery legislation last year, which again have gone nowhere. They've been kicked into the long grass. So we simply don't know when the rest of it's going to come along. So watch this space. We'll be in touch if you more pay clients and we see things that are going to happen. We'll let you know about them.
Great, thanks, Mike. Moving on to the next question. The next question is, should I issue written particulars before an individual starts? Now, I think Linda did touch on this in the presentation and said that it's better to do it on day one rather than beforehand. Is that the case?
Agreed, I would, because if you issue it beforehand, you're actually committing to it legally and you're bound by it. So, and then should things not work out, you're potentially at risk of it being in breach of it. Now, the financial implications aren't huge, but they're still a headache, and we already see it before even this this actually has arrived. We're seeing it now with businesses struggling with the coronavirus, and they've already issued contracts to people who haven't yet started, so they're bound by them contracts legally. So what I would do is make sure that it's issued on day one rather than you're tying yourself to it prior to day one. It just makes sense to me, just in case something goes wrong. Like I say, the coronavirus business is struggling. They've already committed to giving somebody a job and now they haven't got the work for them. So, you know, there's a notice pay implication and a bit of a headache for employers. So for me, I would definitely say do it on day one rather than beforehand.
Yeah, can I just add?
Yeah.
I'd absolutely echo that and think through, are you issuing an offer on a conditional basis? If that offer is still conditional, for instance, criminal record check, health questionnaire, anything like that, where you may want to be able to turn around and say, well, actually, having seen what's come back, references, whatever else it might be, it's a no from us. If you've already issued them with those written particulars, and unfortunately, that is what the government is advising you to do, send them out in advance, exactly as Linda has said. You may find that instead of simply saying, well, sorry, but we're not going ahead with it, that you actually technically have to dismiss someone because you've engaged them by issuing them with contractual documents.
Thank you both. That's really useful, I think, for lots of people that joined the webinar this morning. So moving on to the next question. Do I have to reissue to current staff? So it's another one related to these written particulars.
You'll be delighted to hear no, you don't have to do it as a matter of course. However, there's always a however, isn't there? Someone can come along to you and say, I would like updated written particulars. My experience over too many years suggests to me that most employees don't want to do that because actually they're worried about whatever else they might get stuck on their terms and conditions at this stage that aren't on their original ones. So most of the time people, I've probably got some years, if not centuries old ones sat around somewhere in a dusty file. You tend to hang on to the ones that were around originally and not be seeking a new one. But from an employer's perspective, it may be that you decide for your own good reasons, fundamental changes to somebody's job, that you want to update their terms and particulars, for instance. That's a different matter. But strict answer, simple question, do I have to do it to everyone? No. Only new workers you engage or new employees you engage from the 6th of April.
Thank you, Mike. So the next question is relating to these written particulars as well. We've had a lot of questions around this. Is, will I get taken to an employment tribunal if I don't issue written particulars on day one?
In theory, yes. In practice, probably not, if not definitely not. Let me stick my neck out. You're in the honeymoon period. you've got a new starter. They've started work for you that week. They're not going to be first and foremost saying, where is my contract of employment? Where are my written particulars? They'll be much more interested in sparkling and shining within the organisation. So they're not going to be rushing off to a tribunal. But let's assume that they did. They would still have to wait in the tribunal queue. The tribunal would eventually deal with it. And in the vast 99% of cases, the tribunal can only slap your wrists and say, issue it. It would only be if there was a different case before the tribunal about another matter which turned on some detail that should have been in a written statement that they might do more. Now, that is already law, and they can issue you a fine of 2 weeks or 4 weeks pay for that individual. And I bet none of you have ever had that happen to you, which is why I can with some confidence say it's highly unlikely that people will be rushing off to employment tribunals to get this crazy piece of legislation adjusted to their complete and total satisfaction.
What I would add to that is that the disgruntled people will just tag it on to any claims that they may already put in. So there will potentially be the claims, like just as Mike said, it probably won't come from a brand new employee who's generally happy that they've got a job. It'll come from people that have come on board, been disgruntled about something, and then popped off for one reason or another, whether that's from you or from their own volition, and they'll just tag it on to whatever they're claiming. That's the real risk of not issuing. So just generally disgruntled employees will be tagging on claims for it, but like we say, the happy ones obviously won't be claiming.
Thank you both. Next question is, do we need to do a separate contract for each member of staff, as they will all have different training provision requirements? I think that's one of the things that now needs to be included, isn't it?
Okay, if you're a more paid client, we're looking very, very closely, again, with the aim and objective of saving you as much time as possible. It may well be that you don't have to do anything different than already applies now. We will be, as we reach you in the queue for your annual reviews, we will be looking at the detail of the sort of employment documents we understand that you issue, and trying to ensure that the impact for you is minimised in any changes to the wording. This one, for instance, when talking about training, it may well be possible that most of the clients that we have a combination of principal statements and an employee handbook, and the bulk of the content in that employee handbook is a contractual document. So although the government has not envisaged it, as far as we're concerned, you're supplying two documents, one of which dovetails with the other to give all the details that are required. If you cover off training in a particular way in the employee handbook, the chances are that will still suffice. If there are peculiarities, so you may be employing a professional, such as a solicitor or a doctor, it may be that we have to look at the particular nuances of that situation and give you specific advice for you as an individual client. Likewise, if you're in the security industry, people have to have a qualification in order to undertake certain security work. Lots of our clients do different things. Some pay for that. Some say you've got to get the qualification before you come to work for us. So we will work through with everyone individually to make sure that their documents say that which is right for them. My advice would be at the moment, don't rush at it. Don't put lots of things into your principal statements that you don't really need or you're not sure that you'll need. This is not something, despite the fact it comes in on 6th of April, this is not something that is a huge and urgent issue. You've got much more problematic issues to tussle with at the moment, with things like the dreaded coronavirus. So I put this on the back foot. We will, if you're more paid clients, we will be in touch with you very promptly over the forthcoming weeks and months to make suggestions if we think you need to change. In most cases, you won't need to change anything on your employment documents. Everything that's envisaged is covered, but there may be the odd tweak here and there that's necessary or advisable.
Brilliant, thank you, Mike. We do still have a lot of questions about the written particulars. I think that it's something where there's quite a bit of confusion, and also there's a lot of detail to go through. Another question we received is, when we said that you need to include paid leave such as maternity, paternity in the statement, does this include statutory, or simply when a company pays more than statutory that you would need to state it?
The answer is both, but again, this is what's so crazy about this particular piece of legislation. It's completely unnecessary, because everybody is obliged to provide certain statutory certain statutory leave in addition to people's annual leave if they qualify. So maternity, paternity, adoption, just to name but three. Again, if you're using our employment documents, they will already refer in most of the handbooks that we provide in some detail, in certain of our handbooks in less detail, but enough detail to fulfill the legal provision. All you need to do, if anything, going forward in the principal statement, is to refer them across to what's already in your employee handbook. So if they get on jury service, which is a form of leave, yes, it'll be in the handbook. If they have a bereavement, which is a leave, it'll be in the handbook. It's already there. And all the government has done is panic people and given you potentially extra things that you really don't need to be doing because it's the law. You have to do it. You don't get a choice in the matter, but why we've got this predilection on their part in drilling down and giving you lots of tedious things to undertake, I don't know, I don't understand. There were so many useful things that they could have done, such as the definition of what's a worker, what's a self-employed individual. They've stuck that on one side and created this bureaucratic nonsense in its place. What a joke.
I think that may have answered some of the questions as well, because as Mike quite rightly says, is if you refer to your handbook in the principal statement, in the contracts of employment, then it becomes part of that document. So there's no need to rewrite our document if it's already linked in, basically.
That's really useful. Thank you both. Moving on from this, we have had a question around the holidays. So if we calculate, the question is, if we calculate holiday for 0 hours per hour worked, does the new 52 instead of 12-week rule apply?
The answer is yes. So if they've been with you for 52 weeks, you would calculate it based on the 52 weeks. If they haven't, you would have to calculate it on the time that they've worked for you. But yeah, the new ruling will come in for 0-hour workers, and you will look back on the previous 52 weeks. The law does say 52 weeks. This may be open to challenge in the future. I think we've had some debate on it, Mike, internally, whether it will be tested by case law, because as I think I've seen another question talking about people who don't always work, maybe they work sporadically. The ruling at the moment is saying 52 weeks. Whether that's going to be challenged, whether there's going to be case law that comes up and says, well, you know, I couldn't work for X, Y, and Z, then we'd have to take that on a case-by-case basis and look at it offline and see why they took the time off and why they didn't work in that time, and whether we would apply something else logically to avoid discrimination claims, for example. But the law at the moment is telling us 52 weeks, so that's what we're going to apply.
Brilliant, thank you both. We will now close the questions off there, but if there are any questions that we didn't get to, then we will contact you after the webinar. So moving on, in terms of connecting with MorePay and finding out more about changes that are coming up, there's a whole host of additional content on the MorePay website, which includes our bi-monthly employment law and HR legislation guide. If you sign up to receive our emails, you will receive this on a bi-monthly basis to download. And if you follow us on any of our social sites, we publish all of our new blogs and guides on there as well, so you'll see them flash up on your newsfeed. I hope you found the webinar useful this morning. Thank you for joining us, and thank you to Linda for hosting, and thank you to both Linda and Mike for answering your questions. We'll close the webinar off now, and we will share the slides and recording with you as soon as they're available. Thank you for your time this morning.